When a testator, or a person with a will, dies, a party known as the will proponent submits it for probate. Under Florida law, if the proponent proves that the will complies with formal execution requirements, then any party contesting probate bears the burden of proving the will's invalidity. In re Estate of Carpenter, we explore undue influence as a ground for invalidity. Multiple times, widow Coketine Carpenter expressed intent that her estate be divided between her 4 adult children, Mary, Ben, Sam, and Bill, but she never executed a will to that effect. In her early 50s, Coketine developed cirrhosis of the liver, becoming quite ill and struggling with depression and alcoholism. One day, Mary noticed that Coketine's condition had deteriorated and arranged for Coketine's admittance to the hospital. Mary subsequently contacted her own attorney, Russell Troutman, saying that Coketine wanted to execute a will, leaving her entire estate to Mary, noting some urgency. Troutman drafted the will and went to the hospital. He then questioned Coketine outside of Mary's presence to confirm Coketine's wishes. Satisfied, he had Coketine execute the will in front of 2 witnesses. Troutman kept the executed will. Mary was the only of Coketine's children aware of the will's existence. 4 days later, Coketine died. Mary submitted the will to probate, but her brothers Ben and Bill contested. They argued that because Mary had a confidential relationship with Coketine and actively procured the will, there was a presumption that the will was invalid for undue influence. Mary admitted that she and Coketine had a close relationship, with Coketine relying on her heavily, but she argued that she merely facilitated Coketine's wishes. The trial court held in Ben and Bill's favor, relying on a presumption of undue influence. The District Court of Appeal reversed. Ben and Bill appealed to the Florida Supreme Court.